Hello, and welcome to Chapter 15 in Healthcare Law and Ethics. We're going to be talking about access, use, and disclosure in release of information. So, this chapter has about 5 sections. I'm going to cover each one individually, like I've been doing, and again, I'm going to hit the super high points in this chapter. I don't feel like there's been a lot of students actually access the PowerPoints, or at least not from what I'm seeing on YouTube. So, again, we're going to hit the high points. We're going to start on page 340, and we're just going to do a refresher of some definitions here. So, we're looking at the terms access, use, and disclosure. So, access is the right of the individual to inspect and obtain a copy of his or her own health information that is contained in the designated record set, where use happens internally within a facility. The sharing, the employment, application, utilization, examination, or analysis of that individually identifiable health information within an entity that maintains the information. So they're using it for business purposes. They're using it to actually complete their job functions. And then disclosure. This is the actual release, transfer, provision of, access to, or divulging in any other manner of information outside of the entity holding the information. So these are your actual releases of information to an outside entity. It could be a law office, it could be to law enforcement, it could be to disability, whatever. So you're disclosing the information to an outside party. All right, let's move to our next slide here. Now, just so you know, this slide only has this slide deck we're looking at here only has 40 slides. So this is the modified chapter 15 slide deck that is out there in your module. We're not going to cover all of the information in this chapter. All right, so let's get into release of information. Now, release of information refers to providing access to PHI to an individual or an entity authorized to receive and review it. So again, release of information is different from disclosure, because release of information, I could be giving the access to the individual, so the person who has access to it, or I can also disclose it to another entity. So again, let's say Department of Health and Human Services comes in and they want the information. I have to disclose it to them. So that's where we get those different terms. Okay, next slide. We're going down into ownership and control. Now, this has always been a big thing as far as who owns the information in different data sources that you have. So first of all, ownership of the health record has traditionally been granted to the healthcare provider who generates the record and has physical custody of it. So the hospital itself is the one that's actually creating the information, whether it's on paper or in an electronic format, and they physically control the information. So the health record belongs to the facility. Okay. Now, the record as a primary data source contains information about the patient as documented by professionals who provided the care or services to the patient. So primary source is the actual information by the provider that gave the care. Secondary data sources are created when data is taken from the primary health record. So again, we've talked about these. These are your registries or your indices. So any information we pull out of a medical record and enter into a cancer registry, that becomes secondary data. Okay, let's move on down to access to health information over on the next page, 341. So an individual has the right to control his or her own body and the right to consent or refuse consent to medical treatment as defined by federal and state laws. Similarly, an individual has certain rights to access, use, and disclose his or her PHI as defined by state and federal laws as mentioned above. Again, the HIPAA privacy rule is specific about the access, uses, and disclosures that require patient authorization and those that do not. So if you go back to Chapter 10, you remember which ones actually required the authorization for the patient and which ones were just for public health or for public benefit. says today most statutory and regulatory provisions provide patients with the right to access their health information and offer some means of protecting the confidentiality of the information. This right may also enable a patient to request the use of an alias in place of his or her legal name as a way to provide additional patient privacy protection. Dropping down just a little bit. At the federal level laws, regulations and guidance from the Office of National Coordinator support the right of a patient to opt in or opt out of sharing their health data with your state health information exchanges, as well as allowing patients choice in accessing and disclosing their information from exchanges that store, assemble, or aggregate individually identifiable health information. So there was an initiative to have all of these different health information exchanges so that no matter where you went in the country and you went to a hospital, let's say you were unconscious and you had your ID on you, they could find health information for you from your home hospital or whatever because it would be available in this HIE. But patients have the right to opt in or opt out of that. They don't want their information out there so that anybody can go out there and get it, so they opt out. They choose not to be a part of the health information exchange. All right, let's talk about who can access health information. Well, first of all, we've talked about competent adults. Okay, competent adults, they are mentally and physically competent to manage their own affairs and they've reached the age of majority. The age of majority, again, in most states is 18. We talked about this in Chapter 8. Mississippi, the age of majority is 21. I went back and looked at our bill that I had posted in that module, and it looked like that died on the floor. So there's been nothing else done about changing the age of majority in Mississippi right now. And I'm sure with all the coronavirus situation going on, that's probably not going to come back up anytime soon. Now, a competent adult may also wish to appoint another person to be, again, their personal representative. So we've talked about this before. And then also a personal representative could be your spouse or next of kin. And it could also be an individual who has the durable power of attorney or the durable power of attorney for healthcare decisions. And that's in the bottom of 341. All right, flipping over to 342, we get back into our Uniform Healthcare Decision Act. And so this gives us our priority order as far as who next of kin is, okay? Now, when it comes to decision making, first is your spouse if you have a spouse. If there's no spouse, then you go down to adult child. If you do not have any adult children, it goes to your parent. If you no longer have living parents, if you have an adult sibling, it would fall to them. If you don't have any of those four, then it's going to go to an adult non-relative that's familiar with the patient, so it could be a friend. And then if you don't have any friends, then it's just going to be court appointed, okay? Now it says the adult patient or the personal representative of the adult, and I'm midway through the page on 342 in that paragraph under number 6. They have the right to request, receive, examine, copy, amend, and authorize disclosure of the patient's healthcare information. However, before disclosing any information, the healthcare organization must identify and verify that the requester is who he or she says they are, who they purport to be, and that the requester has the authorization to access the information. All right, let's get back into our incompetent adults here. So again, they could possibly be at or above the age of majority and could become incapacitated, whether that's due to illness or injury, whether it's permanently or temporarily. They can be designated as an incompetent adult. So when this happens, another person should be designated to make decisions for that individual. So again, we come back to durable powers of attorney or durable powers of attorney for healthcare decisions. Now, if you do not have an advance directive, the court system, with support from the appropriate medical community, will declare the individual incompetent, and then the court is going to appoint a legal guardian. Okay? Now, the guardian could be the spouse, an adult child, or a sibling, or another designated person. It is important to avoid the assumption that individuals with mental illnesses are also mentally incompetent. They have to be formally deemed mentally incompetent by a court, okay? All right, let's drop over to minors. Next page, 343. So again, it's an individual under the age of 18 who has not been legally emancipated. Remember, to be emancipated means to be declared an adult by the court, okay? Now, because of their age, minors are generally deemed legally incompetent. That means they're unable to consent for their own treatment or access, use, amend, or disclose their health information. And again, we have talked about exceptions to this. Okay? Some of those exceptions were, again, treatment for STIs, and then also pregnancy, and then alcohol and drug abuse. All right, let's drop down into parental authorization. Now, if you are a minor, it says several categories of parents are recognized by laws. So again, for a minor, these are the people that can actually authorize information to be released or used for minors. So first of all, you've got your married biological. What happened to my what? Okay, let me figure this out. Let's close OneDrive and get back to my slides here. That's never happened before. Alright, let's get back to our list of parents here. Okay, so married biological parents is number 1. Then you have separated or divorced biological parents. You can have adoptive parents, step parents, foster parents, your grandparents, and again, legal guardians. Generally, only one parent signature is required to authorize the access, use, or disclosure of a minor's PHI. In some states, only the mother's signature, regardless of the mother's age, is required. And in other states, it's the custodial parent. And that's again determined by the court on who is responsible for authorizing the use, access, and disclosure of their PHI. Okay? Now, again, when parental authorization is not required. So we talked about some of this. Now, we talked about emancipated minors. Again, the court has appointed them as legal adults. Now, here's a couple of other ones. If the minor has been married or previously married, then they are considered an adult. If the minor is in the military, so if you're 18 years old in Mississippi and you choose to enter the Army or the Navy or the Marines, you are considered an adult. Now, if you're a minor who reaches the age of majority while you are under treatment, you are considered an adult. And then again, alcohol dependency, drug dependency, mental health, STDs, HIV, contraception, and abortion per your state laws, you are considered an adult. All right, our next page, let's see what we got here. Now, let's talk about rights of a non-custodial parent or others, okay? So state laws generally address situations involving the rights of divorced or separated parents as well as grandparents with respect to accessing and authorizing the use or disclosure of a minor's PHI. A non-custodial parent. This is a parent that does not have legal custody of the child. Non-custodial parents are legally endowed with parental rights, which generally allow them to access the healthcare information of their minor children, subject to the situation stated above regarding minors. So this right, which is explicitly stated in the state laws and in the HIPAA privacy rule, can be overridden if the court determines that the denial of their parental right is in the best interest of the child. Now, in absence of a best interest of the child determination, state law should be consulted regarding the specific rights granted to your non-custodial parents. So it says in Tennessee, the law requires that a copy of the child's health records be furnished to the non-custodial parent by the treating physician or the treating hospital upon written request. So again, let's go back and be clear, okay? Parents have parental rights, period. They may not have custody of their children, okay? But they still have access to their children's medical records, okay? Now, unless for some reason it has been deemed in the child's best interest for that parent to not have access, that would be about the only way that they would not be able to have access. Okay? And if you have terminated your parental rights, you no longer have access to that child's medical records. But just because you're a non-custodial parent and do not have legal custody of your children does not mean you do not have access to their health information. Okay? Don't ever let anybody confuse you of that. Non-custodial parents, they have rights to their medical records for their children just like a custodial parent does. Okay? Now, it does say in some states, either parent may authorize the release of information. Now, a lot of times, best practices, we're going to go to that custodial parent first. Because, I mean, why wouldn't we? But either parent may authorize the release of information. Now, if state law distinguishes between custodial and non-custodial parents' rights of access, persons working with the health records of the minors should review the request from non-custodial parents to determine if the disclosure actually complies with state law. So again, we're not saying that you cannot have the information. We're just saying we want to make sure the authorization is correct and right. And if it is, then we'll release the information. All right, dropping down to minors in foster care or allegedly abused. I don't really think we have a slide for that per se. But it says in some states an authorization for the access or disclosure of the PHI of a child in the foster care system can be signed by the appropriate Department of Human Services or Children's Services personnel. Some states delegate this responsibility to the department's designated representative. Depending on the state, a foster parent may authorize the access, use, or disclosure of the child's PHI. However, legal documentation of the relationship is required. Healthcare organizations and providers should not release any information to persons alleged to have abused the child, if known, regardless of the relationship of the person to the child. So if you are a custodial parent and you have been accused of child abuse, then most likely that hospital is going to do what they can to ensure that you do not get the information. But again, it's a tough situation because we don't know. We don't necessarily know what's going on. Now, if we know someone's came to our department and said, hey, law officers have come and arrested the mom of this baby because of suspected child abuse, then we can make notes and we can know, okay, well, this mom has been suspected of child abuse. Okay? All right, let's get into employers. Again, talking about employers, employees, and other members of the workforce, whether or not they can access information. Now, employers that may or may not be HIPAA-covered healthcare entities may request patient information for several reasons. So, first of all, one of them is FMLA. If you're going to have a baby or if you're being put off because of some illness, then they have the right to request that information. They also need to ensure that you can return to work if you've had work-related injuries, and then information for company physicians. Patient authorization is required for such disclosures, but in some states, the patient's employer, employer's insurer, and employers and employees' attorneys do not need the patient authorization to access health information for workers' compensation purposes. So if you have a workers' comp claim, they do not have to have your authorization to receive your records. All right, dropping down to employees. Employees of a HIPAA CE are categorized as either directly involved or not directly involved in a patient's care. Although those involved directly in the patient's care, so nurses, aides, case managers, physical therapists, respiratory therapists, and so on, do not require authorization to access the record. So that's just common sense. You know, we're going back to TPO, Treatment, Payment, and Healthcare Operations. So if I'm an employee and I'm taking care of a patient, I don't have to have that patient's authorization to access their medical records because I'm using it for treatment. And then again, we're talking about the minimum necessary. I only need what I need to take care of their record. I don't need 15 years of history. If I'm a nurse currently taking care of a wound, I don't need to know that they've had behavioral health issues in the past. You know, I need what's legitimate to me in my care right now. All right, and then physicians. Physicians are classified in numerous ways and thus must be considered according to their classifications for access purpose. So if they're an attending physician, a fellow, a resident, an intern, a researcher, a physician of record versus referring physicians, consulting physicians, you got follow-up physicians, you got treating and non-treating physicians, okay? If they are on the medical staff and they're part of an organized healthcare arrangement and they're treating a patient, then they should have access to that patient's records, okay? Not only for treatment, but also for payment. Because again, they're going to have information to do their billing for their services. All right, let's see. Let me give you an example here. All right, we're talking about I'm a physician, okay? I'm in a hospital and I work at this hospital, and my wife came in 2 weeks ago and had some kind of procedure, and I didn't really know what it was because she didn't tell me. Me as a physician, can I just go in and access her health records? No, you cannot, because first of all, I wasn't treating her. She's not my patient. I didn't perform the procedure. I'm not a follow-up physician. I'm a nosy husband or a nosy wife, whatever the case may be. And so, no, I do not have access, even though I'm a physician in that facility. I'm an attending and, blah, blah, blah. But no, legally I do not have right to access that information because I'm not using it for treatment, not using it for payment. All right, let's go over to the last little section here, 346. Now, students. Let's talk about students. Students enrolled in health-related educational programs, so if you're in a medical program or in a nursing program or some kind of allied health program that are involved in direct and indirect patient care, they should have access to the patient's health records. So again, if I'm a medical student, or I'm a nurse that is going into a hospital for her clinicals, or I'm a respiratory therapist at clinicals, then I should still have information to help me take care of that patient as part of my training program. And I should not have to have the patient authorize me access to the information. Okay, it says a contract or a letter of agreement between the educational institution and a healthcare provider or covered entity that outlines student responsibilities when accessing PHI and patient privacy compliance should be maintained by both parties. So Itawamba Community College and North Mississippi Medical Center and all the other hospitals around the state, they have this agreement in place. So not only can their nursing students and their respiratory therapy students and their physical therapy students and radiology students go into these programs and then go to these facilities and have access to this information, so can HIT students. Just like you go in for your clinicals next semester and you're going to have access to patients' health information. These are real patients. You're not going to have to go have an authorization for the patient each time you want to look at a record for training for your vocation. Okay? All right, attorneys is next on our list. Now, attorneys can or cannot, may or may not be actual employees of a healthcare organization. Now, if you are employed by the healthcare organization, you may be the privacy officer or the risk manager or compliance officer, then you're considered part of the workforce and you do not have to have authorization prior to accessing a patient's healthcare information. Okay? You may be trying to defend a lawsuit, you may be handling collections, or there may be other legal issues that you're dealing with. But because you are part of that workforce, you do not have to have authorization. Now, there are non-employee attorneys that are on retainer. These may be the attorneys that go to court and defend your hospital if a lawsuit comes up. Okay? So they are not part of your workforce. Okay? Now, it says a non-employee attorney who is retained to provide legal representation does not require patient authorization prior to accessing patient information. However, a business associate agreement is required per the HIPAA privacy rule for access to occur. So even though I'm not part of the workforce, I should still have access to the information because, again, I should be considered a business associate and I should have that BAA in place. So remember, a business associate is someone that will have access to your healthcare facility's information in order to perform a service for you. So if I'm a lawyer and I'm going to court and I'm defending you for this lawsuit, I have a business associate agreement in place with you, I should have access to those information, healthcare information that I need without patient authorization. All right, lastly in this section we have vendors. So vendors present in a healthcare organization will often have access to patient information in the course of their work. Such vendors could be consultants. They may be coming in trying to sell equipment and supplies. They could come in and they could be a vendor that you've outsourced to do your release of information or maybe your transcription services. They could come in and be the people that do the laundry for the hospital or provide the food service, or you may have someone coming in and repairing a piece of equipment. Now, if the vendor meets the definition of a business associate, the business associate agreement must be signed. If they're not a business associate, employees of the vendor should sign confidentiality agreements and undergo HIPAA training because they have routine contact with patient information, okay? But neither situation requires patient authorization. Okay, so let's look at check your understanding really quick, and we're going to cut off there for section 1. So number 1, ownership of a health record has traditionally been granted to the provider. That's true. So let's go back and qualify this, okay? Ownership of the health record. So the record, that's the information being put on a piece of paper and being placed in a folder and being filed on a shelf, or the information being typed into an electronic health record. That health record belongs to the actual provider, to the facility that created it. But the information or the data, that actually belongs to the patient, okay? That's why we can allow patients to come in and make amendments to records, okay? So the health record, think about that as the physical embodiment of the information. So it's a paper chart or it's an electronic health record. That physical piece that you're in control of, that's the health record, and that belongs to the provider or the healthcare facility. The actual information, the sentence that states she's a 40-pack smoker, blah, 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 she has high blood pressure, she whatever, that information belongs to the patient, okay? So that's the differentiator right there. Number 2, a patient must allow their health information to be shared with a health information exchange. That's false. Remember, we talked about an opt-in or an opt-out clause there. So if you don't want your information shared, you opt out. Number 3, an emancipated minor may authorize for disclosure of his or her own information. That is true. An emancipated minor has been declared an adult by the court, so they can release their own information. Number 4, employees directly involved in patient care do not require authorization to access the patient's record. That is true. Remember, authorizations are not needed for TPO, treatment, payment, healthcare operations. So if I'm a nurse or I'm a physician or I'm a respiratory therapist, I don't have to have that patient sign an authorization form to let me go look at that record. It's part of the treatment process. I have access. And number 5, attorneys have automatic access to patient information because they are officers of the court. That is false. They do not have automatic access to patient information, okay? So if I'm an attorney working for the facility, then I do have rights to that information, okay? If it is applicable to what I'm doing for my job. If I'm trying to defend for a lawsuit, or if I'm looking at some kind of incident that went on and I'm performing risk management functions, then I can have access to that information. Any attorney out on the street that wants access to a client's health information, they have to have an authorization. So they do not automatically get information just because they're officers of the court. Okay? All right, so we'll stop here. We'll pick up with section 2 in a later lecture. And again, it's going to be super fast, super quick. We're going to hit the highlights. So good luck and happy reading and happy studying.